Factsheet 4.1. Checking your PA has the right to work in the UK. Introduction. Before you employ a new personal assistant, you must check that they are legally entitled to work in the United Kingdom. You must check this for all the PAs that you employ, regardless of their nationality, and you should never automatically assume that someone does or doesn't have the right to work in the UK. This fact sheet guides you through how to make the proper checks and provides information about employing workers of other nationalities. It should be read in conjunction with Personnel Sheet Support Sheet 4.1, which provides you with a checklist of documents that you can use to verify your PA's right to work in the UK. Further information on checking an individual's right to work in the UK is provided by the UK Visa and Immigration (UKVI) on their website at www.government-right-to-employers-guide. Section 1. Checking your PA has the right to work in the UK. Before your PA begins work with you, you must check that they have the right to work in the UK. Your PA's right to work in the UK will depend which country they are from. Unless they are a British citizen or a citizen of one of the European Economic Area (EEA) countries, they may need a visa before they can work in the UK. Every new PA that you employ must demonstrate their right to work in the UK by showing you certain documents that prove this, e.g. their passport. Personnel Sheet 4.1 contains a full list of documents that you can ask to see. When making these important checks, you must never discriminate on the grounds of race, colour, ethnic or national origin, and never automatically assume that someone does or doesn't have the right to work in the UK. Unless you check, you will never know. If you're employing an illegal worker as a PA, you may face a fine of up to £10,000. It is a criminal offence to knowingly employ someone who does not have the right to work in the UK. However, as long as you have carried out the proper checks, you will have established what is called a statutory excuse. This means that if your PA is later found to be an illegal worker, you will be able to show you have done everything that the law requires and you will not be held responsible. Section 1.1. Making the proper checks. The Immigration, Asylum and Nationality Act 2006 requires all employers to make basic document checks on every person they employ to ensure that they have the right to work in the UK. As an employer, you have a duty to ask all new PAs to show you certain documents proving that they have a right to work in the UK before they start work with you. There are 3 steps highlighted below which you need to follow, along with details of the type and number of documents you will need to ask your PA to show you. 1. Ask to see 1 document from List A or 2 documents from List B. You can view List A and B in our Personnel Sheet, Checking the Right to Work in the UK, Support Sheet 4.1. 2. Check the following details. A. The person's photograph matches their appearance and the date of birth appears accurate. B. That the documents are valid and genuine and match up with any details provided on the application form and have not been tampered with. C. That any relevant expiry dates have not passed. D. Any UK government stamp states that the holder is allowed to do the type of work you are offering. 3. Photocopy the documents that you have viewed, including the front cover, any personal details, particularly photographs and signatures, UK government stamps or endorsements, showing the potential PA is allowed to do the type of work you are offering. You should keep these copies on file along with the employee's personnel sheet and employment contract. Section 2. Employing migrant workers. Your PA's right to work in the UK will depend on which country they are from. Unless they are British citizens or a citizen of one of the European Economic Area countries, they will need specific permission to work in the UK, and they must show you the relevant documents to prove this. Section 2.1. European Economic Area (EEA) countries. The following countries are in the EEA: Austria, Belgium, Bulgaria, Croatia, Cyprus, the Czech Republic, Denmark, Estonia, Finland, France, Germany, Greece, Hungary, Iceland, the Republic of Ireland, Italy, Latvia, Liechtenstein, Lithuania, Luxembourg, Malta, the Netherlands, Norway, Poland, Portugal, Romania, Slovakia, Slovenia, Spain, Sweden, and the UK. Although Iceland, Liechtenstein, and Norway are not members of the European Union (EU), their citizens have the same rights as EU citizens to enter, live in, and work in the UK. All EEA and Swiss nationals can enter and live in the UK without needing to apply for permission. However, Croatian nationals, having only joined the EU in July 2013, do not automatically have the right to work here. Section 2.2. Employing people from Croatia. If you want to employ a Croatian national, they will need permission to work from the UK VI before they start, unless they are exempt from doing so under the rules. To apply for permission to work, they must obtain an accession worker certificate from the UK VI, also called a Purple Registration Certificate. More information can be found at www.gov.uk/Croatian-national. When they have been working legally in the UK for 12 months without a break, they will no longer need permission to work in the UK. They can then apply for a blue registration certificate, which confirms their right to work in the UK, although this is not mandatory. Section 2.3. Employing people from outside the EEA. If you wish to employ a PA who is not from an EEA country or Switzerland, it is likely they will need to apply under the points-based system. There are 5 tiers in the points-based system. PA work is usually assessed as falling into Tier 3. Currently, it is extremely unlikely that you will be able to employ personal assistants from non-EEA countries as Tier 3 is suspended. Tier 3. The route for low-skilled workers from outside the EEA filling specific temporary labour shortages is currently closed. As such, it is extremely unlikely that you will be able to employ a PA from outside the EEA at this time. If you would like more detailed information about this process, please visit the UKBA's website. Applying to employ someone from outside the EEA is a 2-stage process. You must A. Apply to become a sponsor, and B. Submit your potential employee to a points-based system. The concept of sponsorship is central to the points-based system. If you want to employ a migrant worker, you must be their sponsor during their stay in the United Kingdom, unless they are coming here for 6 months or less in certain circumstances. Before you sponsor a migrant, you must obtain a sponsor license. For more information on obtaining a sponsor license, see the UK VI's website www.gov.uk/UK-visa-sponsorship-employers. If you are successful in gaining a sponsor license, you can submit a potential employee to a points-based assessment. Points will be awarded to reflect the migrant's ability, experience, age, and level of need within the sector the migrant will be working in. Potential employees will need to score sufficient points to be eligible to work in the UK. Section 3. Completing the personnel sheet. It is vital when employing a new PA that you complete a personnel sheet for your new PA and that you carry out the proper document checks to verify that they have the right to work in the UK. Independent Live's Personnel Sheet Support Sheet 4.1 provides detailed information and guidance on checking your PA's right to work in the UK. The personnel sheet provides you with a list of documents that your new PA can show you to prove that they have the right to work in the UK, and it also provides guidance on how to properly verify these documents. You must take a copy, for example, scan or photocopy each document that they show you and keep the copies with their personnel records. Completing the sheet and keeping copies of the relevant documents will act as proof that you have made the proper document checks. If you do not make the proper checks, you may be liable to civil or criminal penalties. Section 3.1. Civil and Criminal Penalties. From February 2008, a civil penalty system for employers employing illegal migrant workers was introduced. Employers found to be employing illegal migrant workers can be fined up to £10,000 per worker. There is also a criminal penalty, under which any employer who has knowingly used an illegal worker for personal financial gain, i.e. not carried out proper document checks, could face a 2-year custodial sentence and/or an unlimited fine. Further information about the civil and criminal penalty system can be viewed at www.gov.uk/government/organisations/visas-and-immigration. This fact sheet has been produced by Independent Lives for use within its advice and support services. We aim to ensure the information is as up-to-date and accurate as possible, but do be aware some of the content is subject to change. If you would like further advice on this topic, or to access any of the fact sheets or support sheets referred to in this document, please visit www.independentlives.org or call us on 08456 0123 99 or 01903 219 482. This has been fact sheet number 4.1, version the 4th of November 2016.